Welcome, everyone, to today's seminar hosted by the Transnational Legal History Group, part of the Center for Comparative and Transnational Law here at CUHK Law. Today, we are delighted and immensely honored to have with us Umut Özsu, Associate Professor of Law and Legal Studies at Carleton University in Ottawa, Canada. Professor Özsu's talk today will address his new book, Completing Humanity, the International Law of Decolonization 1960 to 1982. In it, he will address the historical struggles to transform or attempt to transform international law in the wake of the successful wave of decolonization efforts that took place around the late mid-20th century. In addition to the book he will present today, Professor Özsu is responsible for many other leading publications in international law, including Formalizing Displacement, International Law and Population Transfers, of which he was the author, as well as the Research Handbook on Law and Marxism, of which he was the co-editor. So in keeping with our standard practice, Professor Özsu will speak for around an hour. After that, we will open the floor to questions from the audience and discussion. Please message me in the chat with any questions you might have, and I will read them out, or I may simply unmute you if simpler. For everyone's information, today's event will be recorded and posted online after the event. So if you're interested in returning to a part of the discussion or sharing something with friends, please know you can access it there subsequently. Without further ado, let me hand over the floor to Professor Özsu.
Hello, everyone. Hello. Thank you so much for having me in this forum. I'm delighted to be here. I'm very happy to have such a large audience, and thank you all for showing up. I realize that it's quite early in Hong Kong at the moment. I happen to be in Canada, in Ontario. Hence the time change. I'm very happy that we were able to make it work. Thank you so much to Christopher Roberts and the faculty as a whole for making this opportunity available. So today I'll be giving a talk on my recently released book, which is titled Completing Humanity. It has just been published by Cambridge University Press. And it is an attempt to provide an international legal history of at least some facets of the process of decolonizing international law, or at least the effort to decolonize international law, specifically in the 1960s and 1970s. And so the bracket of time, the period of time that I really focus on here is 1960 to 1982. For reasons that will become apparent shortly during the course of my talk. And as will also become evident in my talk, I really drill down into 5 key doctrinal and also theoretical or conceptual debates that were raging at the time among international lawyers in the so-called North as well as in the so-called South. The book is really organized around these 5 core doctrinal slash theoretical or conceptual debates. So more on that in just a sec, but let me just launch into it. On October 24th, 1945, when the UN Charter entered into force, an estimated 750 million people, nearly a third of the world's total population, lived in territories under direct or indirect colonial rule. By the end of 1990, 30 years after it adopted the landmark Declaration on the Granting of Independence to Colonial Countries and Peoples and established a special committee to oversee the process of decolonization, this number had cratered to a few million, and the UN General Assembly felt enough pride in its track record to celebrate the inception of, quote, an international decade for the eradication of colonialism. Today, roughly 70% of the world's population is descended from colonizers or colonial subjects, in many cases from both. The experiences of countless occupied territories, oppressed nations, unrecognized states, secessionist movements, and indigenous peoples, to say nothing of those struggling against ongoing neo-colonialism, make it clear that colonialism has not come to an end, and that it certainly cannot be reduced to the formal processes of decolonization coordinated by states and international organizations. But the fact remains that over 80 states gained their independence within a single generation after the Second World War, with most colonial territories thereby reconstituted as states possessed of de jure sovereignty. Fewer than 2 million now live in the 17 territories that continue to be designated as non-self-governing on the UN's admittedly incomplete and controversial list. Now, how was it possible for a transformation on this scale to unfold so rapidly? What was international law's role in it? Decolonization, as a historical process, certainly did not arise ex nihilo after the Second World War. Its histories include the Haitian and Greek revolutions and the independence of settler states in the Americas during the late 18th and 19th centuries. Nor was decolonization ever limited spatially to Asia, Africa, Oceania, and the Caribbean. In Central and Eastern Europe, for instance, new states were created after the Second World War, as they were after the dissolution of the German, Ottoman, Russian, and Austro-Hungarian empires 2 decades earlier. The very term decolonization, which seems to have first appeared in print in 19th century discussions of France's occupation of Algeria and the Mexican-American War, was popularized during the interwar period by German émigré economist Moritz Bonn, who translated his neologism, Gegenkolonisation, into English as a way of conceptualizing what he regarded as a long-term development stretching back to the American War of Independence. Yet, the heyday of decolonization came after the establishment of the United Nations, an organization often distinguished from the League of Nations by its recognition of what one observer called, quote, the need for accommodation in a revolutionary stage of transition. This was a time when nations and peoples the world over secured formal emancipation from colonial rule. It was also a time when many pushed to fashion a new and decolonized international law. The specific dynamics and mechanisms differed from time to time and place to place. The removal of direct imperial control was a different matter, for instance, from the termination of a protectorate arrangement. A so-called peaceful transition in one territory might well be complemented by rebellions and counterinsurgency operations in a neighboring territory. Some colonial powers welcomed withdrawal as a means of shrugging off increasingly burdensome legal, financial, and administrative responsibilities, as well as the prospect of enhanced migration, free-time French Prime Minister Edouard Herriot had in mind when declaring in 1946 that France did not, quote, wish to become a colony of her former colonies. Others resorted to brutal violence to suppress independence movements, as well as related protests and uprisings. In the words of Amilcar Cabral, the Marxist and Pan-Africanist revolutionary, Portugal could not, quote, afford the luxury of practicing neocolonialism, being too weak to retain economic control without forcibly maintaining political control. And this was why its effort to hold back the tide of history was ultimately doomed. An international legal history of what many have come to term the long 1970s. My book, Completing Humanity, documents the rapid rise and even more rapid fall of the most sustained attempt to decolonize international law ever undertaken. It commences in 1960, the year of the Decolonization Resolution, and it concludes in 1982 with the close of the Third UN Conference on the Law of the Sea and the onset of the Latin American debt crisis. The post-war push for decolonization began in the late 1940s and 1950s, unfolding alongside a boom in development planning. But its political and economic consequences made their force felt on the plane of international law most fully during the 1960s and 1970s. Growth in the per capita income of many developing countries slowed during the 1950s and 1960s, and the UN designated the 1960s, 1970s, and 1980s as development decades. Formed in 1964, the year after the General Assembly adopted the Declaration on the Elimination of All Forms of Racial Discrimination, The UN Conference on Trade and Development, or UNCTAD, became an important venue for discussions about economic development, particularly in regard to problems of unequal exchange. That is, the long-term downward trend in the price of primary commodities, especially those produced in peripheral states, peripheral, of course, is a term of art at the time, relative to the price of manufactured goods. By the mid-1970s, though, the post-war cycle of global economic expansion had sputtered to an end after years of declining rates of profit for many US and other firms, hard on the heels of the effective demise of the Bretton Woods monetary order following Richard Nixon's decision to take the dollar off the gold standard in late 1971, and the first of the decade's two major oil crises in 1973-74. Building on deals they had struck with trade unions and working class movements during the interwar period, the national and transnational capitalist classes of the post-war North Atlantic had entrenched broadly Keynesian models of counter-cyclical demand management, partly through a significant expansion in the capitalist state's authority and capacity to provide social services. This had stabilized capitalist social relations in most industrialized countries, raising wages, employment levels, and rates of profit from the late 1940s through the mid-1960s, the core of what is still often regarded as a golden age for global capitalism. By the 1970s, however, competition-induced overproduction in the United States and the introduction into its markets of goods from Western Europe and East Asia, particularly Japan and West Germany, increased pressure on US corporations and state institutions to weaken organized labor, drive down wages for domestic workers, jettison high-cost lines of production, relocate manufacturing abroad, and deregulate the financial sector. These developments expose the contradictions in the post-war class compromise. Brought together through open distaste for Keynesian managerial techniques and a commitment to the price mechanism, neoliberals like Friedrich Hayek and Milton Friedman came to enjoy greater power during this juncture, jockeying for influence with socialists and partisans of reform packages like the New International Economic Order, or NIEO, in a contest to reconfigure the world economy. The world of floating exchange rates and increased capital mobility that resulted from such struggles was littered with new commodity and value chains, stifled by persistent suppression of growth in real wages, undergirded by ever more complex legal and logistical structures, and characterized above all by frequent recessions, asset bubbles, and financial crises. A tumultuous tide of historical and political developments roiled these shifting forces. The Vietnam War, India's annexation of Goa, Daman, and Diu, the Soviet invasion of Afghanistan, colonial wars in Portuguese Angola, Guinea, and Mozambique, the 1967 and 1973 Arab-Israeli wars, conflicts and massacres in Cambodia, Ethiopia, Indonesia, Lebanon, Nigeria, and Pakistan, and a large number of national liberation movements that did not always prove amenable to tidy legal distinctions between international and non-international armed conflicts. These were the years of second-wave feminism and the space race, the Soweto uprising and the Iranian Revolution, the 1975 Helsinki Accords and the strategic arms limitation talks, the measles vaccine and the 1972-75 worldwide food crisis, the normalization of neoliberal models of legal and economic reform, first in Europe and the United States and then elsewhere, went hand in hand with the operational breakthrough, as some have characterized it, of transatlantic human rights organizations, devoted in the first instance to combating torture and defending prisoners of conscience. Military dictatorships rose and fell in Southern Europe, Latin America, and elsewhere, even as anxieties about silent springs and limits to growth circled out of the fringes of environmentalist activism and economic policymaking to seep into popular consciousness. It was in this rapidly changing context that the last major waves of decolonization unfolded. Driven to achieve and reinforce their sovereignty and independence, states struggling with legacies of uneven colonial era development and often bundled together in a nominally uniform third world, the term is generally traced to a 1952 article by French social scientist Alfred Sauvy, began to organize themselves on the international legal plane. They did so in significant part through the non-aligned movement, the NAM, and the Group of 77, the G77, formed in 1961 and 1964, respectively. They also worked through UN bodies like UNCTAD, also established in 1964, and the General Assembly, particularly its fourth committee, responsible for considering special political and decolonization-related issues, and its sixth committee, responsible for considering legal matters and producing draft conventions. Some of the new states, as they were oftentimes called at the time, identified first and foremost as capitalist or socialist, with different interpretations of those terms in the offering. The majority, though, elected to position themselves as non-aligned, a term that Nehru had used in the late 1940s and that began to enjoy widespread popularity during the 1960s, often being used interchangeably with older and more explicitly geographical expressions like Afro-Asian. As the debates of the 1960s gained steam, the ideological troika, as some called it, of capitalism, socialism, and non-alignment, or neutralism, gained increased visibility, circulating alongside post-war distinctions between developed and developing states. The roots of this large and pivotal network of non-aligned states, committed to maintaining distance from a first world of market capitalism and a second world of supposedly democratically deficient socialism, have typically been traced to debates about independence, self-determination, and resource sovereignty in the late 1940s and 1950s. In particular, they've been linked to the 1945 Pan-African Congress in Manchester and similar meetings in Africa, the 1955 Bandung Conference, and growing reliance upon non-European conceptions of international law, such as the Panchel, or Five Principles: non-aggression, non-interference, peaceful coexistence, equality and mutual benefit, and respect for sovereignty and territorial integrity. The Panchel, of course, was a set of principles to which Nehru, China's Zhou Enlai, and many others expressed fidelity. In reality, though, they stretched back to interwar communist and anti-imperialist organizations like the League Against Imperialism, a transnational network of communist and anti-colonial militants. After holding its first formal meeting in Belgrade in September 1961, 5 years after Yugoslavia's Tito hosted Nehru in Egypt's Nasser for preliminary discussions, the NAM, the non-aligned movement, began to translate many of the claims made during these and other meetings into new arguments about international law. Its efforts interlaced with the work of a variety of new organizations: the Cairo-based Afro-Asian People's Solidarity Organization, the New Delhi-based Asian African Legal Consultative Committee, the Soviet-backed International Association of Democratic Lawyers, the Havana-headquartered Organization of Solidarity with the Peoples of Asia, Africa, and Latin America, and the World Federation of Trade Unions. A range of political and intellectual networks grew after the Second World War, facilitating cooperation between activists and prisoners in the colonies and cause lawyers and other progressives in the metropoles. Developing a competitive tension with US-sponsored groups like the International Commission of Jurists and the International League for Human Rights, their meetings interlaced with the gatherings of a growing number of UN bodies and regional groups like the Organization of African Unity, founded in 1963, the Association of Southeast Asian Nations, founded in 1967, and the Caribbean Community, founded in 1973. International legal arguments, old and new, were woven in and out of the ensuing discussions. The interstate system was undergoing significant change, and so too were the legal structures that formalized its distributions of political-economic power. By the mid-1960s, it was clear that neither economic depression nor two global wars had been enough to generate the sort of world state about which legal theorists like Hans Kelsen and international lawyers like Louis Son speculated in the 1940s and 50s. Desire to forge a new international law was nothing new. It was prefigured in the Universal Declaration of Human Rights as invocation of a right to a social and international order in which other rights might be realized. It was also reflected in Chilean jurist Alejandro Alvarez's call for, quote, a new international law grounded in equity and oriented towards social interdependence, in a separate opinion in the 1949 Corfu Channel case before the International Court of Justice, or ICJ. But the topography of international law had been reorganized, complicated by a growing détente whose implications would be felt in everything from nuclear non-proliferation to intellectual property law. The Cold War's East-West axis was now complemented with newer relations between a global North and a global South. These terms also really come to emerge in the mid-1970s. The push to reconstitute international law so that it might accommodate these changes and become a force of economic and political emancipation came to the fore powerfully at the time. It found expression in what some called, quote, the eagerness of the new states to participate actively in the life of the international society, a desire that fueled the creation of new foreign ministries and diplomatic services, the move to formalize their admission to the United Nations, and the growth of new networks of knowledge production in the Southern Hemisphere. It also involved a dual strategy marked by considerable tension. On the one hand, jurists and diplomats from the predominantly non-aligned new states sought to conserve those elements of the international legal system generated after the Second World War and constitutionalized in the UN Charter that underscored the foundational status of sovereignty, non-intervention, and territorial integrity. The goal here was to harness international law's normative and ideological appeal in order to minimize foreign interference and support state-building projects designed to produce rapid and sustained socioeconomic transformation. Typically supported by their counterparts from socialist states, Third World lawyers and diplomats defended those elements of international law they deemed useful for the achievement and consolidation of national sovereignty. State forms inherited from colonial rule or adapted from broadly European models, and the legal frameworks that formalized and legitimated them were not to be cast aside so much as revamped, and in some cases, partly radicalized with a view to augmenting control of natural resources. Perhaps it may even be said to be a matter of surprise that so much respect has been shown for the traditions of Western Europe, scoffed one US international law specialist in 1966, turning his conceit into hostility by adding that this remained the case, quote, apart from occasional psychopathic reactions that relate rather to matters of policy than of general international law. Such arrogance aside, it was hard to deny that the further universalization of international law, even in substantially transformed form, facilitated the further universalization of both European state structures and the capitalist world economy to which they were integral. International law's expansion and development was at root a reflection of capitalism's own expansion and development. On the other hand, those who gave legal voice to the Third World also underscored shared experiences of colonial and semi-colonial domination. They did so in order to establish collaborative institutions premised on shared need and mutual benefit. However committed they may have been to safeguarding their newfound sovereignty, those governing the world's newest states were keenly aware of their institutional limitations and economic dependence on the very powers from which they had liberated themselves formally. Most believed that cultivating trade partnerships, attracting foreign investment, consolidating political and military alliances, and fostering regional organizations with powers of functional coordination were central to their security and prosperity, even their survival. Julius Nyerere, the first prime minister and president of the independent Tanganyika, and long-term president of its successor Tanzania, was widely influential for his vision of Ujamaa, a cooperative society led by a one-party state that prioritized rural development, harnessing key industries and natural resources to this end, and in which collective ownership was instituted through the villagization of production. Notably, though, even he merged this commitment to national sovereignty with a broader commitment to building a new international order. Nyerere is widely known for his dedication to self-reliance, the view that, as he himself put it, a country or a village or a community cannot be developed, it can only develop itself. But he also affirmed the need for developing states and peoples to forge a common front on the model of an international trade union, admitting that prioritization of political and economic independence did not reduce their need for foreign aid, technical assistance, and capital investment. Most Third World jurists and diplomats towed a similar line. They defended the developmental state as an engine of social transformation. At the same time, they were active participants in transnational and intergovernmental networks seeking to accelerate international law's own transformation. Cutting across social, geopolitical, and ideological lines, the Third World's international lawyers frequently found themselves supporting mechanisms of interdependence that complicated their adherence to state sovereignty. Now, forging unity out of such diversity was never an easy task. Given the rivalries between decolonized states and the shifting vectors of US and Soviet power, with wars, coups, famines, partitions, and forced migrations accompanying the resulting political and military struggles, designing a coherent legal program to socialize sovereignty into a new world order was almost as difficult as actually seeing it through to completion. The tension between national sovereignty and international solidarity fueled political imaginations and rhetorics of statecraft in North and South alike. Much of what congealed to form modern international law, what we call now modern international law, after 1945, was designed to ensure the dominance of great powers while facilitating liberalization of a world economy undergoing rapid expansion. In the 1960s and 1970s, questions were raised about how this law might be universalized in light of decolonization, and how closely it would track earlier models of statehood, jurisdiction, and recognition. For German Jewish emigre international lawyer Wolfgang Friedman, writing in 1964 from his position at Columbia Law School, the international law of coexistence, rooted in 19th century European thought, was in the process of being replaced by a new international law, one devoted first and foremost to cooperation. This new international law of cooperation, the expression would be Friedman's most abiding contribution to the field's lexical warehouse, would reinforce national sovereignty, not by authorizing autarky, but by fostering regional or functional groupings of states, quote, often developing in mutual antagonism until such time as common faith or necessity may bring about a truly universal world order. In practice, such cooperation called for the elaboration of new doctrines, so rarefied that they rose as far as the moon and other celestial bodies, even as far as outer space in some cases. It also called for advocacy of more prosaic proposals for technology transfer and common development funds. In 1972, well on his way to becoming a leading scholar of international law, Indian jurist R.P. Anand adopted a position broadly similar to Friedman, arguing that, quote, a common law of mankind is a sine qua non in the present expanded world society. For Anand, this, quote, universal law of nations, though insufficient to do away with differences of opinion amongst the new states of Asia and Africa on the one hand, and European and North American countries on the other, was not indicative of any, quote, irresponsible attitude of the new states, which remained dedicated to the concept of the sovereign territorial state and accepted the binding authority of the UN Charter and most key post-war treaties. In his view, it was clear that the new campaign, quote, to establish a universal world order reflected, quote, a revolutionary change on the international scene, with international society having become a true world society after forcing 19th century Eurocentrism into retreat. It was crucial to develop an international law, he thought, that was, quote, responsive to the needs of the new factual situations to which it is being applied, and also illustrative of, quote, a consensus of the entire world community, including the new emerging states. Leaving aside, quote, occasional outbursts against the present system of international law and demand for its adaptation to present-day conditions, recently liberated states did not, quote, plead for its overall rejection. Instead, they had, quote, come to accept international law as such, and they always plead their cases according to its rules, often to the point of claiming, quote, to be scrupulous adherents to it. For Anand, post-partition India's acceptance of the binding legal character of more than 600 treaties and agreements, going back to early 19th century instruments with the East India Company, was only an illustration of the general tendency of, quote, Asian African countries to accept the old treaties concluded on their behalf by the former colonial powers until they are modified, renegotiated, or replaced with the consent of the other parties. Now, as is well known, many European and American lawyers of the late 19th and early 20th centuries relied upon models of world order rooted in explicitly or implicitly racist theories of civilization. In some cases, most notoriously Scottish natural lawyer James Lorimer's 1883-84 Institutes of the Law of Nations, German law scholar Franz von Lys, 1898, Das Völkerrecht, and the writings of Cambridge jurist John Westlake, they proposed models of jurisdiction and recognition that disaggregated humanity into distinct groups and ascribed different sets of rights and obligations to each. Lorimer's own schema, a particularly oft-referenced legal justification of European empire, consisted of fully civilized states, quote, barbarous or semi-civilized states, like the Ottoman Empire, meriting no more than semi-sovereignty and saddled with capitulations or unequal treaties, and, quote, savage regions that supposedly fell short of the minimum requirements of, quote, organized political communities. These are all, of course, Lorimer's own terms. The modern international law, cobbled together after the Second World War, maintained an uneasy relationship with these earlier classical forms of international law. But it too was racked by contradiction. The UN Charter spoke of the equal rights and self-determination of peoples, but it also stressed its respect for sovereign equality and non-intervention in matters falling within domestic jurisdiction. Its text made no mention of civilization or any standard of civilization. Yet, the organization for which it served as a kind of constitution boasted an executive branch in which 5 self-selected states enjoyed veto powers, continuing a tradition of multilateral global rule stretching back to the concert of Europe. It was also comprised of a legislative branch whose chief function was to issue resolutions widely understood to be legally non-binding in almost every instance, as well as a reformed League of Nations mandate system, which carried its sacred trust of civilization into the UN trusteeship system and its own sacred trust toward non-self-governing territories. The ICJ took over the mantle of the World Court from the League's Permanent Court of International Justice in 1946, but its enabling instrument counted, quote, general principles of law recognized by civilized nations among its sources. And the numerical weight of these civilized nations on the court's bench drew as much scorn as its 1966 decision in the Southwest Africa proceedings that Ethiopia and Liberia had no legal standing in regard to the question of that territory's status. These inconsistencies were evident enough, the stuff of performative contradiction and diplo-legal tu quoque. Lurking behind them, though, was a more fundamental question. To what extent was it justifiable to characterize states formed through decolonization as newly independent, or even as new? Many states presented themselves as having arisen through the restoration or reversion of a sovereignty that predated colonial encounters and which had never been extinguished. Some denied they had ever rightly been colonized. Algeria is a good example of that. A state could be viewed as an entirely new subject of international law, free and clear of pre-existing legal encumbrances. It could also be regarded as the colonial state's legal successor, in which case it would typically be saddled with debts and duties initially assumed by the preceding administration. As noted by Richard Falk, the American international lawyer who acted as counsel for Ethiopia and Liberia in the Southwest Africa case, the rhetoric of newness also, also made it difficult to understand why Yugoslavia, neither new nor Afro-Asian, quote, was typically grouped together with these states, while Rhodesia under white settler rule, despite its evident geographic qualifications, was typically not included. Emphasized by Charles Alexandrowicz, the peripatetic Polish legal historian who spent significant time at the University of Madras during the 1950s, this question struck at the heart of debates about the degree to which new states inherited treaties and other legal instruments like concession agreements. The argument that states formed through decolonization succeeded to most such instruments, made notably by New Zealander jurist D.P. O'Connell, was countered by the argument, voiced powerfully by Algerian lawyer and diplomat Mohammed Bajawi, that such states emerged free and clear of their predecessors' legal obligations. Nyerere himself advocated a compromise position of sorts, according to which the new state would be afforded an opportunity to consider these legal obligations and decide which, if any, should be retained. This compromise found support in the work of many third world international lawyers, with Indian American professor Prakash Sinha pointing out that newly independent states distinguished pragmatically between, quote, treaties which represent burdens inherited from the colonial past, and, quote, treaties which enable their continued participation in the normal life of the international community. The question of new states also had important implications for customary international law. Third world states had a real interest in reinforcing certain types of customary international law, since this was the body of law in which they sought to anchor the authority of General Assembly resolutions, where their strength grew significantly during the 1960s and 1970s. Unlike most international lawyers from industrialized countries, third world international lawyers tended to support the thesis that General Assembly resolutions constitute binding customary international law, even after that view received a blow in the 1966 Southwest Africa judgment. On the other hand, Many rules of customary international law, particularly in its general form, had emerged on the basis of relations between European states, with little direct participation on the part of non-European states and peoples. As Mexican lawyer and diplomat Jorge Castaneda wrote in regard to foreign investment, a vital outlet for northern capital that typically yielded generous returns, the relevant rules, quote, were not only created independently of the interested small states, but even against their desires and interests. What was called customary international law had to a significant extent evolved behind their backs, without their conscious deliberation or direct involvement. And so there was little reason to believe that it warranted immediate trust or respect. Third world representatives were aware of the role played by the Soviet Union and other socialist states in the creation of new international law, including customary international law. They were also aware of Soviet support for most positions of the NAM, the non-aligned movement, and the G77, within and beyond the General Assembly. At the 1922 Genoa Conference, the first case of Soviet participation in a large multilateral diplomatic conference, Maxim Litvinov was reported to have declared that, quote, there was not one world, but two, the Soviet world and a non-Soviet world, with, quote, no third world to arbitrate between them. Litvinov's successors in the decolonization era could not adopt such a posture. They elected instead to present international law as a useful framework for coordinating the wills of different states, facilitating peaceful coexistence with capitalist states, and furthering the interests of proletarian internationalism in connection with socialist states. Like their Chinese allies turned rivals, Soviet officials were conscious of the leverage afforded by their ties to decolonized states, just as they were aware that such leverage could be used to reorient customary and other forms of international law. In many cases, especially where change is needed, the situation of the newly independent states resembles that of the Soviet Union in its early days, wrote a young Georges Abissab, the Egyptian international lawyer, in 1962, already on his way to building a reputation as among the most influential of all third world international lawyers. Customary international law was a reflection of inequality on the international plane, but decolonization had brought to the surface what Venkata Raman called its, quote, democratic potential, its promise to give prescriptive voice to, quote, the common interests of the whole community. Socialist support for third world positions in and beyond the General Assembly was important in this effort, providing the third world with additional votes and leverage repeatedly during the 1960s and 70s. Above all, though, the most significant contradiction of the international law of decolonization turned on the relation between national sovereignty and international order. For the lawyers and diplomats who wrote and spoke on behalf of the world's economically and politically weaker states, national sovereignty was to be defended, not by spurning international law, but by augmenting and reconfiguring it in the service of stronger relations of interdependence. The new international law of cooperation, Friedman's term, was not antithetical, but supplementary to and transformative of the older international law of coexistence. At its sharpest, this transformative project encouraged incisive critique of existing legal structures and of international law's role in shaping and justifying both capitalism and colonialism. It also called forth ambitious formulations of law's capacity to catalyze social and economic change, even romantic dreams that a world of cooperation and mutual prosperity might one day be built. The decolonized states of Asia, wrote Indonesian international lawyer J.J.G. Seatau in 1961, were torn between their need for, quote, closer contact with other countries to ensure economic development and their sensitivity to the sacrifices necessary for their newfound independence, which conferred upon their newly acquired sovereignty, quote, a halo of national sanctity. Seatau himself saw this as reflecting not, quote, the luxury of capriciousness and arbitrariness, but rather a tendency to, quote, accept part of the body of international law and reject the remainder, at times acting with, quote, egotistic purpose, and at other times, quote, walking on tiptoe through this treasure house with unnecessary diffidence and a lack of critical sense. This was, quote, a legalistic as well as a non-legalistic approach, he observed, in what could just as well have been a motto for the international law of decolonization itself. As Indonesian officials put in a paper prepared for the NAM's summit in September 1973, where preparations were made for the NIEO's formalization in the General Assembly the following spring, quote, the problem is not simply one of radical rejection, which at this stage may in some cases prove self-defeating, but rather of the need for worldwide regulation of rights and responsibilities to the common benefit and justice for all. And that's a statement I found in the UN archives. Completing Humanity, this book, is a socio-historical analysis of an international legal field, as Bourdieu would call it, in transition. Post-war decolonization breathed legal life into self-determination, spawned the development of new conceptions of resource sovereignty, and led to doctrinal innovations like jus cogens and the common heritage of mankind concept. Far from going by the wayside or entering a period of protracted decline, international law expanded rapidly and remarkably during the long 1970s. My book focuses on the interventions and scholarly writings of a regionally diverse group of elite international lawyers from the Third World, nearly all of whom, it is important to note, were men. The names read like a who's who of late 20th century international law, also, unfortunately, itself mainly an affair of elite men. George Abissab, R.P. Anand, Upendra Bakshi, Mohamed Badjawi, Mohamed Bennouna, Boutros Boutros-Ghali, Jorge Castaneda, B.S. Chimney, Taslim Elias, Francisco Garcia Amador, Kamal Hossein, Kebab Mibaye, Satya Nandan, Radhabino Paul, Ibrahim Shihata, Isa Shivji, M. Swarnaraja, JJG Siatal, U.O. Umozurike, Christopher Weir-Mantry, and Hassan Zakaria, among many others. Most of these lawyers hailed from the upper or middle classes in their home countries. Badjawi, an orphan raised in a working-class neighborhood in Algeria, is a notable exception. Most were social democrats or socialists of one or another persuasion. A small but vocal and powerful minority drew from the Marxist tradition. Chimney and Shivji are its most articulate exponents. Nearly all of them received training, partly if not entirely, in elite European and North American universities, sometimes in politics, economics, or other disciplines, in addition to law itself. And nearly all occupied positions of considerable legal and political power throughout their careers, from time spent advising national liberation movements or holding down ministerial posts, to years in the world of commercial arbitration or on the bench of an international tribunal. Their writings, learned, wide-ranging, and often crafted with poetry as much as precision, were published in progressive law reviews like the Howard Law Journal and mainstream academic outlets like the British Institute of International Comparative Law affiliated International and Comparative Law Quarterly. They also appeared in newly founded Third World periodicals like the Indian Journal of International Law and the Arab League-oriented Egyptian Review of International Law. These and countless other publications showcase the reach of the new international law then under construction. The professors, practicing lawyers, dissertation authors, state functionaries, and revolutionary militants who struggled to transform international law during the 1960s and 1970s may not have had an Institute of International Law or an International Law Association of their own. They did, however, play leading roles in a broadly shared project of reshaping international law. This was a project with inherent limitations, political as much as theoretical, and it ultimately produced only partial results. But it is still the most sustained enterprise and large-scale transformation ever attempted in international law's formal force field. In addition to figures from the Third World, it's important to note the book examines the views and writings of international law specialists from capitalist and socialist states who became involved in various facets of the decolonization project. This group, once again, unfortunately comprised overwhelmingly of men, included Suzanne Bastide, Derek Bowitt, Antonio Cassese, Charles Chaumont, Percy Corbett, Ingrid Detter, John Dugard, René Jean Dupuy, Richard Falk, A.A. Faturos, Charles Fenwick, Maurice Fleury, Thomas Frank, Wolfgang Freeman, Louis Henkin, Rosalind Higgins, Wilfred Jenks, Robert Jennings, Philip Jessup, Manfred Laux, Myers McDougall, Arvid Pardo, Bert Ruhling, Oscar Schachter, Julius Stone, Grigory Tunkin, Michel Virali, Gillian White, and Quincy Wright, again, among many others. Aside from their writings, these figures often trained or lent assistance to their counterparts in the Third World, with many from Africa, Asia, and Latin America spending time in the universities of Britain, France, Switzerland, and the United States. The struggle to decolonize the theory, doctrine, and institutional architecture of international law was spearheaded by young lawyers and legal scholars from the Global South, but many of their counterparts in the Global North were willing to provide significant support. Joint conferences involving participants from both North and South or different states in a given region were held regularly. The American Bar Association convened a series of large regional and international meetings as part of the World Peace Through Law project it launched in 1958. The UN, the International Commission of Jurists, and the Carnegie Endowment for International Peace organized conferences and training courses the world over. These events ran alongside meetings like the 1967 African Conference on International Law and African Problems in Lagos, a landmark conference at the Indian School of International Studies in New Delhi the same year, and a series of Nigerian legal reform and institution building conferences that culminated in the creation of New Commission of African Jurists in 1963 and its subsequent absorption into the Organization of African Unity. If Third World figures gained influence in the international legal field during these years, it was partly because key members of the still preponderantly Euro-American Invisible College of International Lawyers understood that their discipline's authority and legitimacy depended upon its ability to adapt to decolonization. As studying changes the legal theory and doctrine over historical time, my book considers 5 key debates about international law during the 20th century's last major wave of decolonization. This is a process of formal legal emancipation and substantive social transformation that reached its peak in the long 1970s. It is also a process that has never come to an end, as demonstrated by recent ICJ cases on Israel's West Bank security wall, frontier disputes in Western Africa, questions of sovereignty and self-determination in the Indian Ocean and Southeast Asia, and the persecution of ethno-confessional minorities in Myanmar. Each of these debates was concerned with basic questions of international law's status and structure in a world of shifting distributions of power and authority. In no sense were these 5 debates that I concentrate on the only such debates at the time. From traditional doctrines of international legal obligation, as understood by judicial and arbitral bodies, to the outer limits of international law's recognition of human and people's rights, gender equality, and ecological sustainability, few of the rules, practices, and institutions that comprise the social field of international law today remained untouched by decolonization. Disputes broke out and battle lines were drawn in nearly every quarter of the field. Even so, I argue, the 5 debates on which my book focuses, each turning on the form and substance of a specific concept of international law, illuminate with a special clarity the stakes of the Third Worldist bid to transform international law. So what I want to do at this juncture with the time remaining, which is about 15 minutes or so, is give you a kind of précis, kind of blow by blow of the 5 chapters that together comprise the bulk of my book. And that will give you a sense of these 5 core debates that I focus on in the book. Chapter 1 focuses on collective self-determination, the first of the book's 5 core legal concepts. It does so by analyzing the negotiations for the 1970 Friendly Relations Declaration, the high watermark of efforts by socialist and non-aligned states to win support for an expansive interpretation of national self-determination. As a cornerstone of the effort to forge a new international law, the concept attracted an extraordinarily high degree of interest after the Second World War. Lawyers and diplomats from the global north typically argued that the right to self-determination could be exercised in a number of different ways, from reconstitution into an independent sovereign state, as the formula went, to loose association or confederation. They also contended that self-determination, understood as a human right, could be secured through adequate political and legal recognition within existing states, and did not therefore necessarily require secession or outright independence. By contrast, those speaking on behalf of the states and peoples of Asia, Africa, and other zones of decolonization generally frame self-determination in broader and more capacious terms, as a right to economic sovereignty no less than political sovereignty. Arguing that formal independence meant little if newly sovereign states remained hampered by earlier arrangements, they called for an international redistribution of rights and resources, which they saw as the realization of self-determination's promise. They also stressed that the right to self-determination permitted armed struggle against colonial and occupying powers, contemplating provision of military and other forms of assistance for that purpose. Crafted through close engagement with such arguments, the 1970 Friendly Relations Declaration formalized an unsteady provisional compromise between these 2 approaches, encouraging self-determination, but never so far as to destabilize a fragile interstate system undergoing extensive reconfiguration. Chapter 2 of the book concerns the concept of international jus cogens, examining the process through which this concept, jus cogens, was introduced into international law during the 1968-1969 Vienna Conference on the Law of Treaties, the first large-scale treaty-making conference involving a significant number of new states. The 1969 Vienna Convention on the Law of Treaties, the conference's final product, recognized jus cogens by endorsing the view that some rules of international law command a universal authority in application. Formerly limited for the most part to cases of piracy, slavery, and the slave trade, jus cogens now found expression in Article 53 of the Vienna Convention, which declared that, quote, a peremptory norm of general international law is a norm accepted and recognized by the international community of states as a whole as a norm from which no derogation is permitted, without, of course, famously specifying exactly which norms counted as such. But the negotiations whereby jus cogens entered into the law of treaties were marked by wide-ranging debates about the nature and limits of the treaty-making power, and ultimately about the basic structure and orientation of international law more generally. On the one hand, were lawyers and diplomats from socialist and non-aligned states, for whom the concept of jus cogens was potentially useful as a means of undercutting the legality of unequal treaties, colonial concession agreements, and other substantively unjust instruments. On the other hand, were lawyers and diplomats from leading industrialized countries who were thoroughly committed to upholding the traditional principle of pacta sunt servanda, the sanctity of compacts, and deeply skeptical of any attempt to introduce a nebulous spectrum in which a select group of legal rules would have controlling authority over all others. As the most abstract of all abstractions imagined on behalf of decolonization's international law, the meaning and scope of jus cogens was thus contested from the very outset. For Taslim Elias, one of the leading international lawyers and judges of his generation, and a key player in the Vienna negotiations, the Vienna Convention was to be celebrated for proclaiming, quote, a new universal principle, a new public order for the moral guidance of states in their future treaty relations. Of course, no such new public order ever materialized, but this was certainly not for lack of effort on the part of jus cogens' partisans and enthusiasts. Chapter 3 examines the concept of permanent sovereignty over natural resources, as it was articulated in the NIEO and the debates that engendered it. Comprising the core of the NIEO program was a call for enhanced aid, debt relief, and technology transfer, as well as the establishment of a specific international right to development, the stabilization of primary commodity prices, the normalization of preferential and non-reciprocal treatment for developing states, and the institution of mechanisms of regulatory oversight in regard to foreign investors and multinationals. But arguably its most significant element was the push to consolidate the legal status of the idea of permanent sovereignty over natural resources. This idea first rose to prominence in UN discourse in 1952 on the back of a series of nationalizations, running from Argentina to Iran and presenting itself on both sides of the English Channel. Among other things, its champions argued that ownership and control of the natural resources of the relevant territory is an essential and necessary element of statehood, one that involves the right to nationalize foreign-held property, in addition to pursuing tactics like acquiring majority interests in corporate subsidiaries or requiring them to hire nationals of the host state. By contrast, those opposed to strong formulations of resource sovereignty contended that no principle could be said to entail rights to expropriate or nationalize the assets of foreign investors without compensation. They also insisted that the quantity of such compensation should be determined by international law or through international arbitration in the event of disagreement. Most aspects of the NIO program, including resource sovereignty, had been debated for some time, partly during broader discussions of neocolonialism, uneven development, and the question of a long-term deterioration in the terms of trade for commodity producers within UNCTAD, where international lawyers like Abi Saab mingled with revolutionaries like Che Guevara. Yet, it was only in 1974 that the project, the NIEO, was formalized in a set of General Assembly resolutions. The program was largely the expression of a desire on the part of political and legal elites in the Global South to renegotiate their roles in the world capitalist system, reforming rather than repudiating the existing international order. Even so, it was never fully implemented. Those demands that saw the light of legal day being diluted in a tortuously tedious process marked by circular negotiations and protracted delays. By 1982, the NIEO was effectively dead. The outbreak of the Latin American debt crisis, the consolidation of neoliberal policymaking in Washington and London, and increasingly elsewhere, and the normalization of structural adjustment in lending to developing countries all combined to sound its death knell. Chapter 4 considers debates about the concept of common heritage of mankind, or common heritage of humanity, as it is more routinely characterized nowadays, during the 1973 to 1982 UN Conference on the Law of the Sea, the third UN Conference on the Law of the Sea. Once US President Harry Truman, proclaimed US authority over the resources of the continental shelf's seabed near its coast in September 1945, only a few weeks after Japanese officials surrendered aboard the USS Missouri, many Latin American and other countries advanced jurisdictional claims of their own over ever larger portions of the world's oceans, issuing declarations or adopting domestic legislation to that effect. Running against the grain of traditional legal rules about freedom on the high seas, these national claims, quote, are rolling out to sea like the great flow of lava which is engulfing the Icelandic island of Heimaey, worried US international lawyer and former ICJ judge Philip Jessup in 1973, adding pointedly that they, quote, could consume the patrimony of the international community. This phenomenon of creeping maritime jurisdiction, as it was called at the time, raised the possibility of an unregulated and destabilizing scramble for maritime rights, resources, and territories, culminating in what was often described as the steady and irreversible enclosure of the oceanic commons. It also lent additional urgency to developing countries' calls for a new and more comprehensive law of the sea treaty, one that would reflect their own rights claims. The result was a series of complex and fractious negotiations, with 11 rounds of bargaining stretching across 9 long and acrimonious years. At the center of the negotiations was the question of how the deep seabed and its resources were to be managed, and what precisely it might mean to claim that they fell within the common heritage of mankind. G77 states sought an international organization authorized to manage the deep seabed's resources, oversee its exploration and exploitation, and coordinate the global distribution of resulting benefits. By contrast, industrialized maritime states proposed a licensing a system in which states and corporations would be granted concessions to operate in the international zone, with any new institution being confined to largely administrative functions. Ultimately, common heritage rhetoric proved central to the treaty that was crafted through these negotiations. But the parallel, quote unquote, parallel or public-private system of seabed mining it legalized had the effect of ensuring that the ocean floor's resources would be controlled to a significant degree only by those with financial wealth and technological means. Chapter 5, the final substantive chapter of my book, focuses on the debates about development, human rights, and so-called basic needs that defined much of the campaign to craft a decolonized international law during the late 1970s and early 1980s. In particular, it considers the emergence of the international right to development and the relation between international human rights and poverty reduction strategies like the basic needs approach and NIEO-related discussions. And it does so against the background of the rise of neoliberalism and organized human rights movements during the 1970s and early 1980s. What I do in this chapter is really provide a close reading of the 2 reports that were produced by the so-called North-South Commission, a commission chaired by former West German Chancellor Willy Brandt. It's also known as a result as the Brandt Commission. Building on elements of the NIEL, the Brandt Commission recommended increased aid, lending, debt relief, investment, technology transfer, and a variety of other measures to further growth and satisfy basic needs in the global south. These measures, in turn, would help to slow inflation and reduce unemployment in the global north. Despite its overarching commitment to a renewed form of global Keynesianism, the Commission expounded a broadly rights-friendly approach to development that absorbed many of the neoliberal assumptions then on the rise. Its proposals included greater liberalization of international trade, expansion of markets and market institutions in developing countries, and quote unquote fiscal discipline coordinated with the assistance of international financial institutions. These proposals were defended partly through appeals to the rights and dignity of human beings. Considered alongside contemporaneous debates about development and human rights, particularly the World Bank supported notion of prioritizing basic needs for poverty reduction, the Brandt Commission's published reports thus provide an entryway into the contradictions of the North-South divide that shaped the failed project of decolonizing international law. As Abi Saab noted in 1980, shortly before his Hague Academy of International Law lectures on the Geneva Conventions and national liberation wars appeared in print, there had been a movement, quote, in diplomatic language from the label backward, which was still in use in the immediate aftermath of the Second World War, via underdeveloped, to the current and rather hypocritical one of developing countries. Abi Saab is tracking that discursive transition, that discursive shift. The push to work up an international right to development reflected an attempt on the part of states in Asia, Africa, Latin America, and elsewhere to harness one of the era's defining political metonyms for the purpose of liberating international law from its past. When Reagan and Thatcher dismissed the Brandt Commission's recommendations formally at the North-South Summit held in Cancun in October 1981, that moment signaled the end of the struggle to cultivate an international law of development that would live up to the ideal of an international law of decolonization. So I see now that I've completely finished the hour of allotted time. So I'll end there, and perhaps we can have a discussion. Thank you.
So thank you so much, Umut, for that absolutely fascinating and brilliant book talk. I should say, even before we go into the question and answer session, you know, I've had the privilege of reading the book already, and it is absolutely fantastic, both in terms of providing a sort of unbelievably comprehensive overview of all of the, you know, a massive amount of background material on this period as a whole, on the relevant sort of sub-issues of international law that Professor Özsu was discussing just now. And then also complementing that with these kind of close readings of the key moments within the sort of evolutionary process of sort of advancing these norms or their sort of pushback or defeat or what have you as well. So I highly commend the book to everybody who wants to know more. As you will be able to tell already from this talk, there is a wealth of information here, and that's of course the best way to access it. So we now move into questions and answers. So please, you have two options. You can either send me a question in the chat, Christopher Roberts, or you can use the raise hand function on Zoom, and I will unmute you. I know it's always hard to sort of articulate complex questions in chat. I'm never able to do it. We have some questions already, but I will perhaps take the chair's privilege to kick off the discussions. I guess the question I want to ask first is sort of a very overarching one, which is sort of relative to, right? So we have this period of decolonization. We have these new, you know, these various new areas of international law that you're exploring in the book, where there's a pushback against the existing sort of modalities of power or attempts to create a more egalitarian international law or one that supports the interests of decolonized states. So, you know, my question is, I guess, in the first place, to what extent, you know, and generally speaking, I think it came through for me even more clearly in the book than in the talk. But you know, these efforts are limited in their effectiveness. So I guess both in terms of sort of the arguments themselves that are made and in terms of those limitations, the big picture question is how sort of autonomous is international law as such? How powerful is it? Is this, you know, are the types of arguments that are made against the existing system just what we would expect as power dynamics are shifting? And are the limitations they face what we would expect? And then maybe to put a twist on that makes it possibly a little bit of a harder question. So among the different areas of law that you look at, are there some of them that you think that you found more surprising, that these were the routes that people were going down? You know, some of them are sort of more structurally expected, whereas others perhaps seem more autonomous in the sense of just more unusual or more surprising? And you think there was sort of across the different areas, did the ball seem to get pushed a little bit further in some than others? So I'll open things up with that.
Sure. Thank you. Thank you so much, Christopher. I'm happy to take that on. It's a tough question to answer in the abstract. I, in effect, try to sort of give a kind of answer to that in the conclusion, which is brief, intentionally brief. So after these 5 substantive chapters and so on, there's a brief conclusion, which is pitched in a bit of a different way from the substantive discussions that comprise the substantive chapters themselves. So rather than diving into the nitty-gritty of the legal history and relevant legal theory and so on there, I kind of draw back again to the kind of material that I've been discussing today. Try to sort of get a sense of the bigger picture, as it were. I think it's a fair question. The way that you pose the question of whether international law could be decolonized or might be decolonized, or what it might possibly mean to talk about a decolonization of international law or a process of decolonizing international law. I think that can profitably be approached or understood through the prism of autonomy, of the question of autonomy in regard to law in general or specific fields or areas of law, as you put it. So I think that is actually quite a useful way of sort of diving into the question. To some degree, it is unavoidably true that some areas of law, and certainly public international law, which is really what the book is concerned with for the most part, not so much private international law or what we call transnational law today. It's clear that some areas of international law enjoy a kind of autonomy in the sense that they are either specialized or they've been functionally differentiated into a field of their own. Hence all this talk about 15, 20 years ago regarding the fragmentation of international law and all this. But it's also, I think, fair to say that some concepts enjoy a kind of autonomy that others don't, in the sense that either they've been around for a very long time. Self-determination is one of them. It dates back centuries. People have been talking about self-determination, the principle of nationalities, the related cognate analogous concepts, and so on for centuries in the European context, but well beyond that. Or because that field, the field in which that concept registers, has sort of taken on a life of its own, and it has its own sort of orientation or trajectory, right? I think it's a difficult question to answer in the abstract. What I'm interested more than the question of, do these concepts actually matter at the end of the day, is, what are the different claims and arguments that, different groups, different clusters of international lawyers, but not only international lawyers, are making at different junctures in response to different political and economic and social and cultural pressures in this force field, in this social field of international law. Understood not only in a discursive or rhetorical sense, but in a very material and institutional sense as well, a power political social field. And when you approach the question in that kind of socio-legal way, right, it yields unexpected results sometimes. So one of the things that is actually quite fascinating, doesn't quite answer your question, but it kind of goes to it obliquely, are the personal and professional trajectories of some of these folks. So one of the people who ends up exerting a significant amount of influence over the concept of permanent sovereignty over natural resources as it develops in and outside the UN system through the 1950s, 60s, and 70s is someone by the name of Henry Carleton. Henry Carleton is a Palestinian. And he's a Palestinian who was dispossessed during the Nakba. And after the Nakba, he essentially sets up shop as an oil and gas lawyer, right, in Syria and elsewhere. And so it's fascinating to me how those sorts of experiences feed personal and professional investment in particular legal concepts as a vehicle of social change or economic development or so on and so forth, right? That kind of trajectory, that kind of experience, is an absolutely fascinating thing, and it can you can go down rabbit holes all over the place with that kind of stuff, right? So I think we need actually more work along those lines. Not necessarily biographical pieces as such, but pieces that actually sort of delve into the specific personal and professional trajectories of some of these folks, because that's ultimately, how these concepts end up doing the work that they do, or not do the work that they're intended to do. Permanent sovereignty over natural resources is an intriguing concept, and it is a staple concept within the sort of doctrinal canon today. It's bundled together, packaged along with self-determination, as we all know. But in practice, it doesn't necessarily yield the kinds of results that folks in the 1950s and 60s, like Carleton and many others, were hoping for. So I'm not sure if that really goes to your question, but it's not an entirely satisfactory answer to your question, but it kind of goes there.
No, fantastic, yeah, and very interesting. Sort of I think Bourdieu appeared briefly in your talk, but those, and I could tell in the book too, there's sort of some degree of inclination to move it. Like we got some details about everybody, but not quite as much as one might also present. Thanks so much
Exactly.
for
Thank you.
that absolutely fascinating talk. Let me urge everybody once again, right? If you were interested in what you heard today, there's a wealth more of information in the book itself, Completing Humanity. So I urge everybody to check that out. I'm sure everybody is forcibly muted here, but I'm sure they will join me in thanking Professor Özsu for that.
Thank you.
Brilliant way to start our days. Thank you for coming in from the evening in Canada, filling our heads with good ideas as we start our Tuesdays over here in Hong Kong.
No, thank you, Christopher, and everyone who was here. I realize it's very early, and thank you, Agnes and Aman and everyone else for your questions as well. I truly appreciate them.
Yeah,
Thank you.
it was, and perhaps we will be able to welcome you in Hong Kong one day, one of these days.
Hopefully, and you in Canada.
Yeah, likewise. Thank you.